Hello everyone, this is Mridul Kumar Pandey, and in this video we are going to talk about some of the constitutional provisions that are dealing with industrial relations, labor laws and social securities. We have divided it into two parts, that is fundamental rights and DPSPs, directive principles of state policies. Fundamental rights under part 3rd of our Indian constitutions are enforced by law, but DPSP, directive principles of state policies under part 4 of Indian constitutions could not be implemented by the force of law because these are only the moral obligations on the state, not the compulsion on states. Because the thing is, right now we are not having enough funds, enough resources, and the current circumstances of the nation could not provide us the enough opportunity to implement each and everything under DPSP. But yeah, we are moving towards it, and we are looking forward uh, on a way or scope of how to implement these DPSPs. So now let's talk about the fundamental relations, the fundamental rights that are dealing with industrial relations and labor laws. The first one is right to equality under Article 14. Yeah, in the eyes of law, everyone is equal irrespective of their class, their designation, and all these things. So again, this is related to the industrial relation, because industrial relation or labor laws are up to some extent are related to the class division, right? The labor class and the ruling class, the capitalist class. Then Article 19(1) Part C of Indian Constitution, that is the right to form unions and associations, provides the right to form trade unions, the labour's associations, and all these things. Article 19(1) Part G provides the right to practice any profession, trade, and business. And then Article 21. Now this is interesting. Article 21, that is right to life and personal liberty. How it is related to industrial relation, labor laws, and social security? Actually, there is an interesting case, that is Yadav versus JMA Industries. In this case, the Supreme Court has held the right to life enshrined under Article 21. Actually, it includes the right to livelihood, and therefore the termination of the service of any worker, any employee, without giving him reasonable opportunity of hearing is unjust, arbitrary, and illegal. So, in this way, Article 21, that is the right to life, is again providing the right to livelihood, and under the right to livelihood, any employees cannot be directly terminated without giving him the opportunity of hearing, and without giving him the proper justification for this termination. Then Article 23, that is the right against human trafficking and forced labor. And Article 24, that is child right. It's about the child rights against work under hazardous factories, mines, and all. Okay. Then we have Article 39. Now, what is Article 39? It is under DPSP. Article 39 is basically the right to an adequate means of livelihood. Everyone is supposed to have an adequate means of livelihood, but this is not the enforced nature of law. This don't comes under the enforced nature of law. It is again the moral obligation on state to provide an adequate means of livelihood to each and every citizen of the nation. Then Article 39A, that is providing the legal aid to each and every citizen, and obviously the worker and all. But again, it is the moral obligation. Everything under DPSP is moral obligation. Then you have Article 41, that is right to work and education. Article 42, just and human condition of work and maternity relief. Now we have maternity benefits. Then why it is under Article 42? It is already implemented. But no, all the companies, all the establishments are not bounded to follow the maternity relief, because the establishments having less than 10 employees are not supposed to have maternity relief things. They are not supposed to implement this maternity benefit, and they are not providing the maternity benefit to their employees. Now Article 43, that is living wage, decent condition of work. Yeah, living wages should be provided, and that wages should be enough to provide a decent standard of life to the workers. Again, it is just the moral obligation. Then Article 43A says workers' participation should be there in the management. Any decision taken up by the management, there should be the workers' participation in it. We are trying to implement it, but again, it is not implemented in 100%, because there are multiple approaches and of industrial relations, and under some of the approaches, it could not be implemented. So all these things are some of the constitutional provisions dealing with industrial relations, labor laws, and social security. Now, if you have any doubt related to this, you can you can just write in the comment section and feel free to reach out to me. If you like this video, hit the like button, share it with your friends, and you can subscribe our channel Intellectual Nexus for more such videos. Thank you for watching this video. Bye.